I'm happy to be here. I'm always happy to visit Missoula. I believe I help add to the local economy almost every time I come, in one way or another. Today, we're having a meeting to engage in an intergovernmental exchange among the federal, state, and local government that's open to the public. Our purpose today is not to solicit public input, although if we have time at the end, we will likely offer that opportunity as time permits. Before I sort of give some introductory remarks that provide a context for this discussion, we think probably should do the introductions of the folks here at the table so we all know who each of us is. On my left is Jim Snow from the USDA Office of General Counsel, who's provided legal advice throughout the development of these easement updates. And we'll keep going to the left.
I'm Joe Brenneman, Flathead County Commissioner.
Jessica Anderson, Congressman Denny Reber. Maren Olson, Congressman Denny Reber. Maureen Connor, Granite County Commission.
Ken Weber, Jefferson County Commission.
Harold Leidy, Executive Director of the Montana Association of Counties.
Rem Mannix, Paul County Commissioner.
Susie Browning, Granite County Commission.
Dale Bickel, Missoula County's Chief Financial Officer.
Pat O'Haron, Missoula County Staff.
Anne Mary Dussault, Missoula County Chief Administrative Officer.
Larry Anderson, Missoula County Commissioner.
James McCoveth, Deputy County Attorney, Missoula County.
Fred Van Valkenburg, Missoula County Attorney.
Bill Carey, Missoula County Commissioner.
Jean Curtis, Missoula County Commissioner.
Al Harper, work for the governor.
Mary Sexton, Montana Department of Natural Resources Director.
Jennifer Ewan with Senator Max Baucus's office.
Tracy Stone Manning with Senator Tester's office.
Virginia Sloan with Senator Tester's office.
Clark Conroe, Mineral County Commissioner.
Tim Reed, Mineral County Staff.
Dan Miles, Senators County Staff.
Gail Patton, Sanders County Commissioner.
Carol Brooker, Sanders County Commissioner.
Great. And I'm Mark Ray, as I indicated earlier. At the heart of the matter that we're going to discuss today is, I think, a responsibility to balance four separate interests. The first of those interests is the interest of the federal government as a land steward of the lands that are in federal ownership and entrusted to the agencies, including the Forest Service, to manage. The second interest is the interest of other levels of government, in this case primarily state and county governments, in some cases as landowners themselves who have holdings that abut the federal estate. The third interest is the public interest, as that has been formulated and defined in laws enacted by Congress, which is the measure of the public interest that executive branch agencies have to go by. And the fourth is the private interests of non-federal landowners, in this case Plum Creek. But absent any direction from Congress, that is, a basis in law, to distinguish Plum Creek differently than any other non-federal landowner, then we don't have the right to treat Plum Creek separately than we would, say, an elderly ranch couple who wants to retire from ranching to town and needs to sell their ranch to fund their retirement. The history of access across federal lands to non-federal lands and across non-federal lands to federal lands was one that was worked out informally through the 1940s, the 50s, and the early 60s. Some cases it was worked out amicably, in some cases not. Because in some cases it was not, Congress enacted legislation in 1964 called the Forest Roads and Trails Act to set the framework for how reciprocal access would be negotiated between federal and non-federal landowners. In 1969, Congress passed the National Environmental Policy Act that imposed on federal agencies the responsibility to do environmental analysis and public review of actions that affect the quality of the environment. Since 1969, whenever the Forest Service has granted a new easement or a new right of access, That kind of public and environmental analysis has been a prerequisite for the grant of a new easement or a new right. In 1980, as a result of concerns brought by non-federal landowners, Congress acted again. In the course of passing the Alaska National Interest Lands Conservation Act of 1980, Congress decreed that federal agencies, land managing agencies, had a responsibility to grant non-federal landowners reasonable access to their property if that required access across federal lands. That piece of legislation, while embodied in a piece, that amendment rather, while embodied in a piece of legislation dealing with Alaska, was written to have a nationwide scope. It was offered by then Senator John Melcher from Montana, perhaps, I guess, as a result of concerns by non-federal landowners in Montana and elsewhere. Those are the statutes primarily that guide how we work to provide reciprocal access and easements in the case where we have interlocking or checkerboard ownership with non-federal lands. About 18 months ago, Plum Creek started to inquire from a number of Forest Service local offices here in Montana and elsewhere about their desire to change the use of some of the land that they owned. The responses that they got were, as you might expect, from a large number of different places and people, not consistent. In fact, very inconsistent. So the company asked that we look at what their rights are under the easements as they have been developed over the ensuing 4.5 decades, since 1964 to present. Jim conducted that review with others in the Office of General Counsel and concluded that for the vast majority of the easements, the language was unambiguous and express, and that is the grant of easement gave Plum Creek and many, many other non-federal landowners who have similar easements access to their property for whatever use they wanted to put that property to. And I think we have circulated to all of you a brief summary of what we think the applicable law provides for in reviewing the language of the easements, the Roads and Trails Act, and ANILCA. We did indicate to Plum Creek that while their rights were secured in the easement, it would be preferable for us if we could update those easements to reflect a few realities that might occur if they were going to change the land use. And the template agreement, which we've also circulated to all of you in state and county government, provides that update. In that, Plum Creek has agreed to encumber the titles to their properties with the responsibility of the successors in interest to form homeowners associations so that we can deal with an association and not a large number of individuals. They've agreed to abide by whatever the local fire-wise or fire use ordinances are, and they've agreed to express statements indemnifying the federal government from firefighting liability. Now, had we decided that we were going to ignore the language in the easements as they existed and tell Plum Creek, you know, when we wrote these, we thought you were only interested in timber production, what we would undoubtedly have faced from Plum Creek, and quite probably a number of other non-federal landowners as well, are multiple suits in a variety of jurisdictions brought to secure their rights under the language of the easements and under ANILCA. So we think this is a better result than that. Now, some have said, well, maybe it is and maybe it's not. But the broad public ought to have been given an opportunity to evaluate that before any conclusion was reached. And beyond that, there should have been more discussion with local units of government before a conclusion was reached. In the latter case, I think a valid point is made. To the extent that we caught you all by surprise, we apologize. That's why we're here today, to discuss this through to where we go from here and to a conclusion. In the former case, though, raised an interesting problem. If we're not changing the rights that Plum Creek was granted through a preceding public process, why would we start a second public process to do what has already been secured? In some respects, that's essentially wasting everybody's time by saying, we want you to comment on this, but it really doesn't matter because they've already gotten a right secured that we don't have the legal authority to change in any case. So we did not believe that a longer public process would have been beneficial. Fact is that if, for whatever reason, we decide not to go forward with this template, Plum Creek can still develop their land. Any other non-federal landowner who enjoys those rights in an easement that's already been executed after a public process can also develop their land. So what issue on whether we proceed is not whether Plum Creek has those rights. They do. Other people have said rightfully that the Forest Service recognizes sprawl as a major environmental threat. Indeed, the previous chief, currently and previously a resident of Missoula, has spoken passionately and eloquently about fragmentation and sprawl as being one of the 4 primary threats that challenge the national forest system. I agree with that. The issue here is not whether sprawl is a threat to the national forest system or to the environment of Montana or to the states where it's occurring. The issue here today, in broadest sense, is what's the best thing to do about that. In our case, we have made major efforts through a variety of programs: Forest Legacy, the Farm and Ranch Land Protection Program, the Grassland Reserve Program, and the Wetlands Reserve Program, to work with cooperating landowners to purchase conservation easements or other instruments that would incentivize them not to subdivide their land. We've probably spent more of that effort in Montana on a proportional basis than any other state because the need here is probably as great as any other state. Moreover, a major focus of our proposal to Congress for a new farm bill, which is currently pending before the Senate and the House Conference Committee, was to increase the amount of investment in these programs for that purpose and to support other programs, such as some offered by Senator Baucus, that would have similar salutary effects. These are initiatives that have proven success rates by cooperating with affected landowners, such that we've put upwards of 6 million acres nationwide in some sort of conservation protection through an easement, a rental payment, or some other instrument. This is an important environmental concern. It's one we must resolve together through cooperation. And in that spirit, I'm willing to help within the federal framework governing how the different levels of government discharge their unique responsibilities. But I cannot violate the statutes that Congress has given me to implement, no matter how much I wish to do that in the face of responding to an environmental concern. So with the documents that we previously said to you, with that as probably an overlong summary of where we are today, I'll ask Jim if he wants to add anything, and if not, then we're happy to hear your concerns try to answer your questions and talk about where we go from here.
I think you've covered it well.
In Sanders County, the Thompson River, Pleasant Valley Fisher had a conservation easement set on it. We have had a Plum Creek subdivision behind Plains, and apparently another one behind that. And our problem is, how far back are we going over the next 20 years? How much impact it's going to have? Are they willing to give additional conservation easements? Have you discussed it?
We've discussed our willingness to fund conservation easements with pretty much every landowner that's walked in the door and that had a property worth protecting. I won't try to say that we've got enough money in the 4 programs that I listed to buy every easement that we'd like. But I will say that if Congress does enact a new farm bill, there'll be substantially more investments made in that area. And that's what we think the right solution as far as the federal government's role in trying to deal with this problem should be. Because where we can work with willing landowners to effectuate that outcome, we have a win-win-win proposition. We win, they win, the environment wins. Trying to regulate that behavior through regulatory mechanisms that we don't believe we possess, we don't think is going to be helpful.
I guess we kind of look at it as urban, wildland, urban interface sprawl. And in the interface, we've got a huge amount of fire problems. And it's going to get worse as along our, excuse me,
Yeah, I know what you're saying. And we're the ones who have absorbed the largest increase in firefighting costs, primarily as a consequence of the growth of the wildland-urban interface. I'm extremely sensitive to the concern, but that level of sensitivity doesn't empower me to write new laws. I think the folks from the legislative branch of government may be where you want to go with that in terms of looking at the question of whether new law is necessary. The federal government looked at the question of whether it was the best level of government to regulate private land use last in 1974. And the conclusion of a majority of the House and the Senate was not to proceed. And since that time, the federal state-local relationship has been one where zoning and land use regulation has been the province of state and local government. If we're going to change that, maybe we should. If we're going to change that, it will require a change in statutes.
So, Mr. Ray, you said one of the things that that Plum Creek has agreed with in regard to Firewise was to indemnify the federal government from firefighting costs. That just means that somebody else picks up that, because those folks still expect us to protect homes built in that urban interface. And I think we put a map behind you there. All the red is Plum Creek, all the green is Forest Service, and you can see what the impact is. That's Missoula County. I have another map that shows all of western Montana, which we're not the only county affected by any means. So what that means is that every single one of those squares, which is 640 acres, in Montana by statute, and we've talked about it here a lot of times too, whether or not folks, how do you give people property rights without putting all the costs on local government, which is the same people paying? Everyone can be divided into 4 blocks with no review. So that's 4. So every square on there could now have 4 homes. Then, because they have not gone through subdivision law, in Montana we have an exemption called a family transfer exemption, that you can give land to your children or your parents. And the commissioners have to grant that, but unless we think they're evading subdivision law, we say yes. So if somebody has 4 kids, pretty soon you've got a lot of houses out in that interface. And I think it's the goals of your agency and it's the goals of the state and the local government to not put people in places that are threatened by fire, but also that impact the environment. It's our council's belief that even though all the laws that you address today are in place, they're still subject to NEPA when you're changing it from a logging road. And we could take you for a drive today. It's too bad you weren't here about a month ago, though, because we've had some nice weather that's probably dried up a lot of roads. We have spring breakup every year here. Any logger that's trying to get to any of those lands is out of the woods. They're not working because you can't get a logging truck through, you can't get a bulldozer through, and you sure can't get somebody's car going to their house through. So I guess that's our concern, is that it seems like if these are going to change from logging roads that have limited use when they're logging in certain seasons to roads that need to be accessed by residents who want to live there, plus people who are going to be there to protect them. What if they need an ambulance? What if they need a fireman? We believe it should go through NEPA.
Well, here's the language that appears in virtually all of the easements as they're written. Grantee shall have the right to use the road on the premises without cost and for all purposes deemed necessary or desirable by grantee in connection with the protection, administration, management, and utilization of the grantee's lands or resources. So it says, for all purposes deemed necessary by the landowner. I don't read that as limited to logging. Now, there are easements that have been written by the state of Montana, I understand, and probably by other landowners that are more limited. The problem I have is that these aren't. And the reason that we indemnified the federal government only is that this document is a contract between the federal government and Plum Creek. I can't offer the county any benefits. I can't impose on the county any obligations in a negotiation that involves an instrument that's a bilateral contract between Plum Creek and us that the county's not involved in. I am deeply sympathetic to the facts that you have reviewed. Being sympathetic and being able to do something about it are two separate things. We're not having this meeting in Eugene, Oregon. There's a reason we're not having it in Eugene, Oregon. The state legislature in Oregon has passed laws that restrict the rights of private landowners to develop their land. Perhaps that's what has to happen in Montana.
And we don't disagree with that, and it's been discussed, and we discussed probably several other legislative sessions. But what we want to talk to you about today is not Montana's zoning, but rather we believe changing their access. If they already have the access, why do you have to address it? That's what I don't know.
Well, the simple fact is we don't have to address it. As I said at the outset, they enjoy the right of access in the easements as they're written. For us and them, the question is, can we do this in a more organized fashion? Can the government get some additional concessions by approaching it in a more organized fashion? Concessions that Plum Creek is not required to give us. And if so, is there a benefit in doing that?
Secretary, I guess I'm a little confused because we've had two fairly large Plum Creek subdivisions in our county, and we had to get easement for them. The county commissioners had to get easement to those subdivisions before they could subdivide. And we had to go to the Forest Service. I worked with my local forest road person, and Plum Creek, they were told that they had to go through the local government to get those easements. And that's the only way they could get those subdivisions. Most subdivisions, it was a very small easement, so the county commissioners went ahead and did that for them. But they were told that they could not develop that property and use that Forest Service road that they already have their documents on, because the county commissioners were the only ones, local government were the only ones that could get that easement for them. So I'm kind of confused as if they already had it, why'd they have to go through all that paperwork?
The simple answer is they probably didn't. They were probably incorrectly advised that they had a responsibility that they don't, unless that particular easement was written differently and more narrowly, in which case then some, that would have been the case. But the vast majority of these easements contain the boilerplate language that I just read. And if Plum Creek willingly went to you to get an easement, they probably did something they didn't need to do, if that was the same boilerplate in that particular easement.
Mr. Secretary, that's the one thing that Missoula County has requested from your offices. If you've been reviewing these, if Mr. Snow's been reviewing these for a year and a half, you must have copies. Could you push copy and send us copies?
Yeah, we're compiling some copies for you right now. And as you know, projected west-wide, there are thousands of these things. They've been written probably every year since 1964, and some even before that, before the Roads and Trails Act.
Mr. Secretary? Joe Brenneman, Flathead County Commissioner. First of all, thank you for coming out and visiting with us. If you brought the nice weather, I hope you're planning to stay for a little while. We need some. You've said there's really no other option other than the course you're on. However, quite clearly, there is another option. We could, or you could, choose to pursue the idea that, in fact, there never was any intention of these being used for residential development. And one of the persons who worked on it says, I stand behind the fact these easements were granted for the purpose of resource management. And my children are the 5th generation in Montana, and 40 years ago, I was only 10 years old, but 30 years ago, when I was hunting on these lands, the idea of them being developed as residential property was so absurd that any language that was written for easements, it would be assumed would be for hauling trees out, because who would want to live here? Now we're in a very, very different environment in which, for some reason, a lot of people want to live there. And the largest landowner has an incentive and has reorganized themselves so they are, instead of a timber company, a land company. Now, initially I understood the argument that we don't want to go to court because we might really lose. But I'm starting to think that as a Flathead County taxpayer representing, I'm not sure what more we could lose. I guess there's a few things being thrown in here for us, but we've had some developments in Flathead County. And one of the problems I have with how things have happened up there is that, like I said, I've lived there for 50 years. I operate a dairy farm. And my neighbor lives up on the hill. He has a beef ranch, beef farm. And his cows get out sometimes, and my cows get out sometimes. And when we see they're out, we go and help the other neighbor put it in. This is the idea of Montana and probably elsewhere, a good neighbor policy. If Plum Creek lived up on the hill and my cows got out, they would call the sheriff to see if they were required to help put my cows back in. Because they have told us over and over, well, fine, pass whatever laws, get zoning, do all this kind of, in the meantime, of course, well aware that they have access to lobbying and attorneys and all kinds of stuff that we don't. And so when we try and talk about the good neighbor thing to do would be, for example, help Flathead County pave for 3 or 4 miles of road going to a subdivision on the end of an 8-mile dusty road with the possibility of an excess of 500 car trips per day. But instead we were sued when we said, you know, please do this, help us out. You can develop it, but help us out that way. Most recently, we discussed firefighting a little bit ago, and the most recent subdivision, Plum Creek, refused to even give up the right to develop one lot because the fire chief had said, well, the subdivision looks okay, except this one section of land is going to be very difficult to provide fire protection for, so let's not divide that anymore. We asked for that. They said, nah, we want to have the most valuable lot we can get, and so we're going to ask you to not do that. And then along with that, and certainly outside of your area of jurisdiction, but our frustration has been in Flathead County, and I guess other counties, is that when the Secure Rural Schools and Community Self-Determination Act of 2000, which was one of the ways of helping us fund fire protection, roads, all that kind of stuff, the administration has refused to reauthorize that.
That's not true.
And so they were one vote away, and we couldn't get one vote to do it.
Well, again, that's the Congress. I'm the executive branch. We've consistently supported reauthorization of secure rural schools. That is a statement of administration policy that's been in existence since 2005.
Well, I won't comment. I would disagree with that because I think it would have.
It was proposed to fund, however, by selling Shore Service land.
That was one proposal. The newest proposal funds it with offsets taken off the top of the budget. I mean, we worked on secure rural schools pretty extensively. I'm sorry Congress didn't pass a reauthorization of it. There's still time. Maybe they will this year. I don't know. But that's something that is now before Congress, not the administration. We've already said our piece. We're in favor of reauthorization. We think it should be reauthorized. But that's not why we're here today in any case. So I didn't mean to interrupt. Go ahead.
No, I'm glad to hear that, and I'm glad to have on record that the administration is in favor of reauthorizing that. That's a valuable bit of information. I appreciate that. My frustration goes with the concept that once again we have, well, Mr. Snow used the phrase cut a deal. We cut a deal with Plum Creek to work out, to find middle ground for the easement issue. There seems a hesitancy to cut a deal with the county governments to make sure that we are able to provide the necessary services to these areas.
Well, I don't think you need us to authorize you to provide those services. That's really...
No, we need the funding. We understand we have a statutory obligation to provide those services.
Right.
But when deals are made saying, okay, you know, and maybe it would have been nice to have asked the counties, look, we realize this is going to have a tremendous impact on you, the county governments. What's the best way to proceed instead of finding out about it 16, 17, 18 months after negotiations had already started? I understand your legal position that there's nothing really to clarify, but the implication to Montana counties is huge.
Well, at the outset, I apologized for catching you unawares, but there's an old saying that we're a nation of laws, not a nation of men. I think probably a similarly true statement is we're a nation of laws, not a nation of memories. And there are lots of people who believed, as you've just said, that the idea that these lands would be subdivided was so out of the question and extraordinary when these easements were written that nobody thought about it. And, you know, that's unfortunate. I was probably 12 years old when many of these easements were written. But the paper is what it is. Now, your question is, well, what if you just sort of ignored that and challenged non-federal landowners to secure their rights through litigation? I guess the question there is, if we lost, we would be no better off than we were now. But if we won, what would we have won? You would have forced, by judicial fiat, the creation of a regulatory program administered by an agency who doesn't have the funding, expertise, or staff to do it, to the disadvantage of 49 other states to solve a problem that seems pretty unique to Montana.
Well, Mr. Secretary, I would suggest you've answered your, if we lost, we'd be no worse off than we are today. That's my point.
Well, no, we would be, because the agreements that Plum Creek agreed to in the template agreement would be lost. So this is what I would call a lose-lose proposition.
Secretary, I just need to kind of clarify something. If we don't have to, we no longer have to get easements for Plum Creek. That's fine. How about any other public, private landowner? Because there's been several other times where we've had to go in and get easements for...
I think you look to the terms of the easement in question, and if it's written with this boilerplate language, I think their rights are expressed.
What if they don't have an easement, written document?
If they don't have an easement, then it's our responsibility to grant that easement.
So we would then, would local government have to do that? Or you would do that with the private landowner?
Yeah, I mean, you can do that if you want to be of service, but you're under no obligation to do so. At the point where a landowner is asking for a new easement, a new right of access, our responsibility under ANILCA is to grant reasonable access. Our responsibility under NEPA is to conduct an environmental review and engage in some level of public input before we grant that access. So in looking forward to the future grant of any new access, those rules, those requirements apply as they've always applied.
Is that a permanent access? I mean, do they have that forever?
It could be permanent or it could be temporary. It depends on the nature of what the landowner is seeking and how much he wants to pay for it, because a permanent easement would involve probably a higher standard of road and more expense.
So do the local rangers, are they going to know, the people that we deal with every day who come to our office once a month and talk to us, are they going to know this then? Or?
That's our hope. By doing the review, clarifying what Plum Creek's rights are and what our responsibilities are, is that we'll now present non-federal landowners and other units of government with a consistent position that is reflected in what was executed in the language of the easements that have been developed. Where there are existing easements. Where there are no easements, there should have been no confusion, because we've been granting easements through a set process over a pretty long period of time.
Yeah, and they've always had to come through the local government in my county.
Yes. You would be involved, as we involved the general public as well.
We've always had to sign off on them. We've always had to take the easements. They weren't granted to the private landowner. They were granted to the public through Sanders County.
Yeah, these are old homesteads up these creek bottoms, and they crossed the Forest Service to get the land. And there was no easement. So we take the easement, and then they had to maintain the road.
Anyway, I guess that the counties probably need to know where we stand on those kinds of easements also.
Yeah, I think on those, it's our responsibility to grant them, not yours, but we certainly welcome your participation.
Well, if you grant them, that's fine, but you grant them to us, not the private landowner.
We could do either.
We could do either, I guess.
Okay.
So it's really a county preference at that point. If you want the grant of easement so that you have more control over the access.
Now, that was never, ever presented to us, though.
Yeah.
Mr. Secretary, to some of us, your statement that these easements in most cases are unambiguous seems legally inconsistent with the conclusion that they need to be clarified. And if they need to be clarified, it would appear that that's a significant federal action that invokes NEPA.
They don't need to be clarified. The policy of implementing them needed to be clarified. They're being updated for the convenience of the federal government with Plum Creek's agreement. But Plum Creek isn't under any obligation to agree to the update. They're not securing any new rights through the update. Now, that having been said, do I believe that somebody will try to make a claim in a federal court that that's not so and that this is different and that this does impose a new obligation on the Forest Service? I can't keep people from petitioning in federal district court, so that may well happen, and we'll have to evaluate that situation as it happens.
You talked also here about essentially by virtue of securing such things as indemnity to the federal government with respect to fire protection, that the federal government was getting a better deal than it might currently have. Why not use the sort of economies of scale that the federal government can employ as opposed to individual counties across the width and breadth of this country to try and do something that really is sort of it works to the benefit of local governments in addition to the federal government? You could do that either with some executive clout, or you could even submit some legislation to Congress that would have the same effect and would have even greater legal force.
Well, on the latter point, I agree with you. We could submit legislation to Congress if we were so inclined. And I'm not ruling that out as I talk with the Montana delegation. It strikes me, though, that it would be unusual for us to submit legislation to Congress that would apply nationwide to a problem that appears to reside here in Montana, and that the Oregon County Commissioners or the Washington County Commissioners might not be supportive of that legislation as new initiatives which intrude on prerogatives that they believe to be their own. So that would be a challenge that such a legislative proposal would have to overcome. In the former case, in response to your invitation that I declare myself emperor and just do this by executive fiat, I'm sympathetic to your concerns, but disinclined to put that robe on my shoulders and try to go beyond what our lawyers have told us is our legal authority.
Mr. Secretary, I don't have to deal, fortunately, I guess, with the Plum Creek issue in my county. However, as things such as this develop, there always seem to be unintended consequences, and that's why I came today. Whether we go as far back as we can and hit things like RS 2477 and discuss the right-of-way issues that go along with public granting accesses, which in my mind states exactly the opposite of Mr. Brenneman, that actually Congress was trying to get people to settle out here and was actually trying to get lands developed even in these areas. And I think that as that's gone forward and we've moved into FERDA and HEPA and and so on.
I do that every once in a while too.
I think that it's a little bit disingenuous to work with a landowner such as Plum Creek because of the volume of land that they own, and yet a smaller parcel, a county, if we want to assert an RS 2477 right-of-way, is bound to go to court to prove that right-of-way, and the burden lays on us. I think it's a bit disingenuous to do that, and I wonder if you could comment on anything as far as the historicity of some easements as compared to these easements.
I don't hold myself out as an expert on RS 2477, and most of the RS 2477 rights-of-way are on Bureau of Land Management rather than Forest Service lands. And I don't think we mean to be disingenuous, but I think we're dealing with two separate circumstances. In the case of RS 2477, the question is, does a county have for to the development of a county transportation system a right across federal lands that was established through the process laid out in RS 2477, which is a little different than the right that Congress created for non-federal landowners under ANILCA. So we have tried to work with counties to prove up RS 2477 rights-of-way wherever we confront them. And if you've got one in particular you think we're being unresponsive on, I'd be happy to talk about it and work with you on it.
Mr. Secretary, if I may return to something that Mr. Van Valkenburg brought up. You have a couple of times today made the case that this really is a local issue. We don't need to address it at a federal level because it's small peanuts or small potatoes, perhaps. As I understand it,
this is a big issue. It's not a small potatoes issue. There's no dispute that this is a major environmental concern. The question is, what's the best way to address it, and what are the appropriate roles of each level of government in doing so?
Well, if it is a major concern, then wouldn't the commissioners in Oregon, the taxpayers in Oregon, Washington, the other states you mentioned, be interested? And in fact, isn't it true that federal land, the person living in Maine right now has as much, so that's his land as much as it is mine, even though I live in Montana, correct?
Yeah, but I think the commissioners of Oregon have addressed this issue. They've passed state zoning and land use laws that restrict the rights of a non-federal landowner to develop their land, whether that land is adjacent to the national forest or whether it's in some other locale.
But that doesn't address the issue that Mr. Van Valkenburg brought up regarding this isn't the only way to look at this. And my point is that I think that the case can strongly be made that, in fact, there is a national interest on these Forest Service lands because residential development that happens on the checkerboards behind Forest Service land, those cars at the rate of 10 per household per lot are going to affect that national land, and therefore it is a national issue.
That case can be easily made. The case that's much more difficult to make is that the executive branch of the federal government today has the authority to regulate that development. And indeed, to the contrary, much of what Congress has done has been to assure that the non-federal landowner has access to its land, not to restrict that access, but to make it a more certain prospect. So you're making a good case, but you're making it to the wrong guy. Not because I'm unsympathetic, but because I don't have the authority to write laws. I just implement the laws that are already written.
Mr. Secretary, getting back to, the NEPA process, I wonder if we could ask Mary Sexton, who's with the state of Montana, if she would share the state of Montana's view on NEPA and access.
Well, Mr. Secretary, Mr. Commissioner, we do have a NEPA process in Montana, and for state lands, when we enter into reciprocal access or when we update reciprocal access or add what we believe to be new rights. And we do go through a NEPA process, even though it may have been done before. And then, of course, it goes to our governing body, to the land board. So it's a very public process, and we have been challenged from time to time for not having it be a completely public process. And I think the issue is, what is the addition of new rights? And I think if it's unclear or nebulous as to whether new rights are being granted or not, we would err on the side of going through the NEPA process.
I think we would as well if it's unclear. We don't think it's unclear here. We think that this language is pretty express and that those rights have been granted, however much we wish they had not been.
Mr. Secretary, I guess I must respectfully disagree because the language, at least in the easements that I've been able to identify, that you've quoted from begins, the sentence that you quoted from begins with the phrase, except as hereinafter limited. And I think that your counsel will probably agree that we have to interpret documents to give effect to language. And when a sentence opens up by referencing limitations, that's not quite consistent with interpreting the language as being without limit. But the issue today, I think we'll all agree, isn't necessarily just strict interpretation of these easements. It's talking about what a public process is or isn't needed before you make a decision on this easement amendment that's been proposed. You've acknowledged that there are major environmental concerns at stake here. You've also noted the benefits of the proposed agreement as adding substantive terms, including the homeowners associations, local firewise standards, and the indemnification clause. How can you tell the citizens in this room that there's no public process due when you're adding substantive terms to thousands of easements nationwide?
The substantive terms are added for the convenience of the government. They don't change Plum Creek's underlying rights. And that's why we didn't believe that a public process was going to be necessary or useful. Because we would be hearing from a large number of people who would be exhorting us to deny Plum Creek their rights. As far as the hereinafter limited phrase is concerned, the problem is hereinafter there were no limitations in the majority of these easements, so therefore the language didn't avail us of anything.
Well, and with respect to that, how do you know that? Because it's my understanding that Exhibit A to this easement amendment has not been prepared, and that in fact the easements have not been compiled and have not been reviewed.
And as they're compiled and reviewed, it's probably a fair bet that we'll find some that are limited, and those will be dealt with separately. And to the extent that Plum Creek or any other landowner is trying to secure a new right, and not one that they already enjoy, then that will require a public process that will involve an environmental analysis and a public comment period.
Well, I think we can agree that the language of those easements is critical. I think you've said that. So how then can you enter into an agreement to amend easements that you don't have knowledge of the contents? You don't know what these easements say. You have taken the position that the majority of them say one thing, but they have not been reviewed.
But that position was based on a pretty good understanding of what the majority of them said. Now, we have some due diligence that we have to continue over a period of a number of months to actually review them in their totality, individually, to make sure that this template is not incorrectly applied to any easements for which it's not applicable, for any easements that are more narrowly written, such that this would convey additional rights. When we turn up those easements, this template won't apply. The easement holder, whoever it is, will have to approach us for a different easement that conveys a broader right, and then we'll have to evaluate how to proceed with that through the normal process that we use anytime we're giving a new easement.
So are you indicating that these easements will all be reviewed before you enter into this agreement to amend the easements?
They don't need to be reviewed before we enter in this agreement. They need to be reviewed to make sure this agreement applies. And where it doesn't apply, we won't use it.
Is there a document outlining the parameters for the application of the easement amendment?
The amendment itself is expressed that where an easement is in conflict with the amendment, the easement prevails.
Mr. Ray, I guess that leads me to maybe a couple of different questions, but let me start with the first one. Do you have a notion of how many easements there will be in the state of Montana that will be amended?
I would guess a couple of hundred in this particular case. but I'm not sure I would say those easements individually are being amended. They're being updated through this template. They're reviewed individually to make sure that this template applies. If it doesn't apply, then they will be amended separately.
If at all.
If at all.
I'm not sure I understand what you just said, so let me try this again. It was our understanding that the proposed amendment that you've shared with us is an amendment that will be attached to each individual cost share agreement. Is that wrong?
No, that's
No, go ahead.
What's contemplated here is, in every county, we're going to go out and we're going to find from the recorded record what has actually been conveyed. Because although our records are fairly complete, they're in innumerable different localities, and what's really important is what's on record. So the next task in implementing this, and it may take several months, it could take over a year or a year and a half, is to identify all the cost share easements that we have with relation to Plum Creek. And then those will be identified. Each one of those will be analyzed, as Mark indicated, for consistency with the template that we have. And if it's in, it's in. If it's out, it's out. And then at some point, we're going to compile this Exhibit A, which is going to be a list by recordation of all the easements to which this amendment will apply. And then the amendment would just be executed on one document for one county. So the Exhibit A might be a list of 50 different easements to which it would apply. And then but we wouldn't be executing 50 different amendments. We'd just execute one amendment, and it would apply to any that were listed. And then, as Mark indicated, the ones that perhaps are outside of the parameters of what we're trying to amend, we would have to deal with those separately, and that might involve a new application under FERDA. It might involve a FLTMA easement. We would just deal with it as we would any other application to change a right-of-way grant. So that's how the process would work. And so even if we gave the green light today to implement this thing, it would be a process that would take many months, even years. This is not as you all know as well as I, it's a very complicated and long-standing set of relationships that have evolved over decades. So we've got to go back in the records, and we'll be doing work with title companies and Plum Creek and others to identify these things. And we haven't done that yet.
So at what point will Missoula County be made aware of the specific easements that will become Attachment A, and will Missoula County be made aware of Exhibit A before Exhibit A is recorded as amended?
In other words, if I can read.
Hold on.
Go ahead.
I think the gist of the question is, would we be willing to share with the counties the easements that would be affected by this before finalizing the lists? And the answer is yes.
And presumably, if you had evidence that suggested it was incomplete or incorrect, I think it would be appropriate to know that.
But I guess to further that, are you still planning to sign the agreement to amend, just not knowing all of the easements you're amending? So you're going to sign with Plum Creek and say, we agree that if the easement says this, we're including it, we just don't know exactly who it is. So in other words, you'll sign with Plum Creek before we ever see the list, even though you might show us the list before you add the list.
There's no contract with Plum Creek until we actually get the list compiled. So that this is a way of beginning that provides some incentives to both sides to add some clarity in this area.
This is kind of an elementary question, but if Plum Creek, they're working on a couple subdivisions right now in Sanders County that they haven't filed with the planner yet. They have legal and physical access? We don't have to worry about that anymore?
If their easement is written like the one that I read to you, yes.
So they would then, they have copies of those easements, so we would just ask them for their easement document?
That's what I would do, yeah.
Because they're not filed in the clerk and recorder's office.
If they're not, then you should ask them for them, yeah.
If they're not recorded, there's a problem.
Okay.
Mr. Ray, could I continue just for a second here?
Sorry, Mayor.
No, Carol, I didn't mean to. Did you get your,
Go ahead.
I'm only doing this for Missoula County, but the questions apply to all of the counties. Are there other non-federal landowners in Missoula County or western Montana that you could identify where there are, I mean, you've said there are many, many other non-federal landowners. Could you articulate who those might be in western Montana?
There'll be a mix of private holders, obviously a smaller size, some non-industrial, some organized as corporations. There'll be the state. There are land trusts, nonprofits, some of whom have actually acquired Plum Creek land. So they would fall in the category of private non-industrial, private industrial, other governmental, state, tribes, and nonprofit.
And as an example of another private industrial, in this case I'll ask a question not just in Montana, but say in the West. Weyerhaeuser.
Weyerhaeuser has a significant number of these easements, any number of real estate investment trusts or timber industry management organizations. In Washington State, the state forest system is very large, and it's probably the second largest owner behind us. In Oregon, you've got the BLM, which is another federal, so that's a little bit different. Tribal lands come into play in some areas as well.
And in your opinion, is this primarily an issue that you'll be dealing with in Region 6, or is this relative to holdings throughout the United States of particularly private industrial uses? I mean, I think that's of most significance to local governments.
The issue of providing reciprocal access between federal and non-federal landowners is an issue that we confront throughout the United States. The issue of concerns over the more intensive development of those non-federal lands occurs disproportionately in regions of the country that are currently growing as opposed to those that are shrinking in population. And the issue of what the relevant state or federal land use requirements are for the non-federal owner is one that varies from state to state based upon the state's regulatory structure. What that means is that the issue that's presented to us as the federal owner varies from state to state. Because in some cases we hear concerns of a certain nature that are not relevant to another state.
That's all for now.
Mr. Secretary, you expressed the desire, I guess, of the department to purchase conservation easements or use other vehicles in a similar manner to protect lands from sprawl and so on. If you're unsuccessful with that, especially in checkerboard areas, will consolidation be more strongly pursued? And then not just with where Plum Creek lands are included, but other checkerboard situations, will that be a stance that you push more strongly here to come? Or?
We do engage in a pretty robust land exchange program as a way to address some of these problems differently. Land exchanges are very complicated because sometimes what you have to exchange doesn't always square up with what the other guy has to exchange in terms of values or desirability. So I don't know that land exchanges are are a panacea, but they are an option that we pursue, particularly in checkerboard ownership, where we've got the opportunity to work with another significant landowner for the purpose of blocking it up. That being said, land exchanges have to go through a NEPA process as well, and they have to go through a somewhat more arduous process of reciprocal valuation so that each party is getting an equal value in the exchange, which involves appraisals and other forms of transactions that usually take a long period of time. I would say we do it, but we do it slowly, and I don't think there's much of an opportunity to speed it up, given what has to be accomplished. Harold?
Harold Black, Executive Director of Montana Association of Counties. Mr. Snow, I'd like to ask you to explore a little bit more the statement you made about existing easements that may be of record, but in particular easements that perhaps were executed but not put of record, so that if the landowner appeared with an agreement that was executed at a point earlier in time but had not been recorded with the clerk recorder in that particular county, how would you view that if presented with that situation? Because I quite frankly think that Commissioner Berger was alluding that that may be something that they're looking at.
Well, I'm not licensed in Montana, so I might want to defer to my colleagues across the table, but typically, if you have a grant that's been properly executed, it's effective as between the parties. Recordation makes that transaction effective against the world. So if there was an intervening third-party right that came in under most recordation statutes, that could defeat the purpose of that easement if it wasn't recorded. So the fact a person has an easement does give them a right generally to use the land unless some intervening party comes in and gets a recorded right that would be contrary to that. So normally if someone walked in the door and had maybe put this in practical context, if somebody walked in the door and had an easement that was signed by the Forest Service back in 1965 and it was never recorded, the Forest Service would honor that easement unless there was a commitment or some type of intervening private right that might have been inconsistent with it. And at that point, we'd have to see what the respective rights of the parties are. Now, if there's some quirk of local Montana law that might be inconsistent with that, I defer to the Montana lawyers in the crowd here.
Mr. Secretary, Rem Mannix, Polk County Commissioner. Stop beating on you just a little bit. I can tell you a little bit of that story. We've got a unique organization in Polk County, which you're aware of, the Blackfoot Challenge. And they have taken the Plum Creek land in Polk County, working through the Forest Legacy Program, which you mentioned, the Nature Conservancy. They have converted 80,000 acres of that Plum Creek land now into private or state ownership, and are working on about another 34,000. So we've taken that approach in working with them. And the Blackfoot Challenge and members of that are an unbelievable organization. They've raised over $10 million to do this at this point. So there are things that are working a little bit, and I can see the problem you've got here and trying to help.
Yeah, and I believe the summer of 2006, I participated in one of the closings that we did with the Blackfoot Challenge, because we are supportive of that. That is, we think, based on the current statutes, the most useful federal contribution to this problem.
Thank you.
Thank you.
Mr. Secretary, you spoke of the indemnification of the federal government in this, and that is to your advantage, and I would agree. It does concern me, though, when, especially in a checkerboard situation, if there were a large fire, how do you view the indemnification of the federal government and the fire that knows no boundary and the cooperation between the state, local, and federal government on such an impact as a fire of that nature?
I don't think this instrument is going to change our firefighting approach. We're not going to alter the unified command system that has worked so successfully in the past, both here in Montana and elsewhere. The purpose of this clause is not to tell people we're not going to put out fires. It's to deal with the homeowner who decides after the fire, if we were unsuccessful in saving their home, that they need to sue us because they don't like what we did or didn't do, as the case may be. So this isn't going to change our firefighting tactics. It's going to provide us a protection against that disgruntled homeowner who maybe thinks that the crew should have borne a higher risk up to themselves to protect their property. And that's, you know, a tension that is regnant in the firefighting community right now. It's, you know, there isn't, since I've been in office, there hasn't been a firefighting season when I haven't gotten some complaints from landowners who say that our crews were not sufficiently aggressive to protect their property. And in most cases, if I sit down and walk through it with the landowner and or one of the crew bosses, what I find is that they did what was prudent, short of putting their own lives at risk in fighting that fire. That doesn't make the landowners feel any better about it afterwards, though, as you know. Other questions?
Mr. Secretary?
Sure.
I guess my concern is public roads. With the checkerboard of Forest Service and Plum Creek land, would it ever be the case that an existing easement used by the public to access Forest Service land, if the Plum Creek was sold for a subdivision, and according to the easement amendment on page 3, item number 5, prohibition, you have that authority to say that it could be a private road. So then the public could no longer access that piece of Forest Service land. What process will you go through to make sure that doesn't happen?
You're asking about a situation where we would want to close a road?
Well, because of the checkerboard, you've got Plum Creek and you've got Forest Service. And if there's a public road that people use to access a piece of Forest Service land, and Plum Creek sells it for a subdivision, supposedly that can't be closed, it can't become a private road. But it also says, item number 5 on page 3, says that you have that authority. And so I want to know what process you will go through if the developer of that subdivision comes to you and says, I want to close this. I want to put up signs and say it's a private road.
We would do that the same way. First of all, we wouldn't be very sympathetic to closing a road. That's the point of these reciprocal agreements, is that we've agreed with our adjacent landowners to keep this road open. So I would not imagine us telling the subdivision residents, sure, we'll close the road now so that you have an exclusive right of access to it. In fact, quite the contrary. Part of this update is to force the formation of homeowners associations so that we can deal with a single entity and not with a stream of people who say, wouldn't it be great if you could close this road? Now, if we were to close a road for resource management purposes, as opposed to the convenience of the new landowner that is adjacent to us, we would go through the same public process we do for road closures generally, which is a notice and comment for a closure that's anything other than an emergency closure in case of fire or something like that.
So if you were going to just limit it to winter recreation or where it had been used year-round, you would go through a public process?
Correct.
Okay.
But the folks that just bought the Plum Creek land would have a key.
We would likely, if we were going to close it to use in that fashion, not be able to restrict their access. So if we had to close it for a resource management purpose, let's say that, as an example, we had a washout on our land behind the subdivision, or rather in front of the subdivision. If we had to restrict access because we had to deal with that washout, we would not be able to prohibit access to the residents in that private land behind the washout, if that makes sense.
And so you mentioned if you did it for resource management, might be some other resource like elk, grizzly bear, whatever, so they would have an exclusive gated community in the middle of the resource center.
Well, the question is whether the resource management issue would present itself in that fashion. And I can't envision instances now where that would be the case, because we'd be wanting to maintain public access in most instances.
But currently, there are gates across many Forest Service roads, at least for portions of the year, in order to protect wildlife and bull, whether it be bull trout or elk calving or grizzly bears waking up or whatever.
Seasonal restrictions, yeah.
Right, and so it seems to me like your agency must be in huge conflict here about going with some old agreements that were given to a company that was Burlington Northern, in a lot of cases, way back when Burlington Northern was given the checkerboard land in order to harvest logs to make timbers to build railroads. It was not part of the Homestead Act. And so it had a totally different intent. And your agency is also responsible for managing those forests and the resources, including wildlife, within them. And so now you're pretty much, it's going to be open season on all that resource habitat that we work so hard to protect ourselves through subdivision.
Well, this isn't, unfortunately, this isn't the only instance where I've got to manage laws in conflict. And if I was the emperor and could go back and change all the laws so they weren't in conflict, that would be a great thing. But unfortunately, that's not an authority that's vested in me. And so we have what we have. And if we need to effectuate a temporary closure for resource management purposes, we will still have to provide the subdivision residents with some access. So temporarily, they may have keys to gates if the situation presents itself that way, if that's the need that presents for resource management purposes. I think, though, that what we'll find is that the areas that are most desirable for development are probably closer in than that. And that's why they are desirable for development.
Have you got a couple weeks? We can take you on some drives. It's not for you.
Mr. Secretary, if I may, for my clarification, as a commissioner, we have a subdivision regulation that requires that communities, developments need a way in and a way out, separate roads, because of, especially in timbered areas, because of fire hazard.
Right.
Having been a firefighter,
That's a good regulation.
it's a good regulation, right. But we have been told by Forest Service that, for example, they have a private road going into this development, and the only way out because of topography is through Forest Service land for the emergency access, or the emergency egress, that the Forest Service cannot guarantee that road will be kept open. The road's available to be used as long as it's open, but because of resource management, we find the rarest whatever in the whole world, and it's in the natural interest to keep this road closed. We have to close this road, okay? And I understand that that's the way it exists in new easements going through the Forest Service. Is that correct?
The way it exists in what sense?
Right. There's no, assume there's no easement in place right now. It's not Plum Creek land, in other words.
Okay. Assume we have to grant a new easement, okay.
Right. So it's Forest Service policy that they are not, you are not in the road business, providing roads. You are in fact resource management. And the roads are there for resource management. So if I understand correctly, with the easements we're talking about today, those roads cannot be closed, as you understand those easements.
No,
that easement cannot be taken away no matter what kind of, and for the sake, I mean, I don't want to be, hyperbole here, but imagine there's a scenario where we find, for whatever reason, it's in the national interest that this road be closed because we need to preserve this species. But the way you interpret the easement language means that that's not an option on Forest Service roads on which Plum Creek or another entity has an easement such as this.
No, the easements do provide opportunities for temporary closures that the Forest Service and the landowners have agreed to. So we've tried to envision why we might need a temporary closure and what the circumstances in which we would effectuate that would be. I think the more interesting question you raised, though, is that if you have a county rule that requires a subdivision developed in the wildland-urban interface have 2 access points, and these subdivisions have only 1 at present, then you've probably got a basis for saying until you've got a second easement, you can't build the subdivision. At least I think that's what I heard you saying.
Well, certainly we would have that, but if, and as a matter of fact, if, so you're saying you can work out temporary closures with the landowners and temporary close the road. Are you also are you then saying that you cannot permanently close that road?
No, we are still obliged under ANILCA to give reasonable access to a private landowner. So if we confront a situation where we want to permanently close an existing road, we still have an obligation to give them an alternative access point that we agree on together before we permanently close the road. Most of the easements, though, have provisions for temporary closures for fire and other emergencies that are written into the easement agreements.
Obviously,
why don't you?
Well, every situation has to be judged on its facts, but the guy's got a property right. He's got an easement. If we take away that property right, we're liable for taking. So we can't take property without just compensation. So if a situation arose where we had to stop him, the likely scenario would be we would sit and we'd negotiate with him and we'd say, we don't want an easement here. We don't like the access here because of its impacts on resources, but we're willing to give you alternative access over here. And in that situation, hopefully we're persuasive enough to get him to abandon this easement in return for another grant over here. So we have options for dealing with it. Now, as far as now if he says no, then we're in a dilemma, because then if he effects the taking of an endangered species, that has some liability. So there's some incentives on his part to want to cooperate. As far as your requirement for dual access into an area, ANILCA only requires us to give him 1 access. And if he has access to his property currently, we don't have to give him a second one in order to effect a requirement required by the county. So in that case, he'd either have to negotiate access or get it from somebody else. And if he can't, I don't think we have any obligation to give him more than what he's already got.
well, to follow up on that then, do I as a governing body, not me and my fellow, at least one other commissioner, if we say, okay, it's okay to put your houses in this subdivision accessed by a easement, the type of which we are discussing here today, with all of its vagaries and confusion, does the possibility exist that at some point then those landowners, all of whom imagine are retired attorneys with time on their hands, decide that, and there is, for some or whatever situation, this road needs to be closed for a bona fide emergency. All of these attorneys, these 640 attorneys on this section of land, sue the county because we allowed them to build homes in an area that they don't have permanent access to. Not only that, she went to a meeting with the Secretary of the Forest Service and he explained the complications. So why'd you let me do it? Are we placing ourselves in a position of vulnerability?
Well, you have to get, that's why you have county attorneys.
They might live there too.
Yeah, these retired attorneys. We can tell you up front, before you grant these things, what kind of access that they have as far as getting access over National Forest System lands. And that's the fact. It's a matter of record. It's there. If someone wanted to apply for additional access, they have a right to do that, but there's no guarantee they'll get it. I'm not sure about how county liabilities would be affected under Montana law, but the fact of the matter is if they entered into a transaction knowing what they had, I think it would be very difficult later for them to justify a lawsuit for the county letting them do what they already knew. So you can't guarantee against every contingency. Though, but can I prevent, I can no more prevent someone from suing the county as I can prevent someone from suing us. All I can do is advise on the best ways to avoid the situations where that might arise.
Mr. Secretary, the invitation email to this meeting by Mr. Nesselrode, I hope I'm pronouncing that correctly.
Close enough.
Stated that broader citizen engagement will be the subject of subsequent meetings. I take that to indicate that there will be some more public process before you make your decision on the easement amendment. I'd like you to outline what that process will be.
I think what I'd like to know from the counties is what your suggestions for additional improvements in this would be. And then if there are some that we can sit down and agree on, I'm inclined to entertain that.
Well, I guess personally, I think you need to go through a NEPA process that accounts for the cumulative effects.
And I think you're going to have to get a court, you're going to have to get a judge to agree with you on that.
Okay, which is why I was asking what process you're envisioning.
Because see, once I just sort of concede that, then I've set a new standard for thousands of easements around the country and invited the next lawsuit from the easement holders to say that they're not under any obligation to wait on the outcome of a second public process to confirm a right that they obtained through a first public process. So I think if you want to make a case that there is, in fact, an additional obligation under NEPA in this document, once again, you're talking to the wrong guy and the wrong branch of government.
I understand that. I was just asking what public process is envisioned, because it seems that it's anticipated that there will be further meetings. I understand your position on NEPA. I'm just asking what further meetings you're talking about.
I think I'd rather see what you all have in mind before I commit to an additional meeting. I mean, we are now kind of where we're at. We've given you our legal rationale. We've given you the document. What I'm interested in hearing from the counties individually or collectively is what you would do differently. And of course, you can tell me that the differences are so fundamental that that's not even a place to begin. And I respect that. You would not be the first county commissioners to sue me. But I think that's the next stage in the process, is for you all collectively or individually to tell me what you'd like next.
And bear in mind, there's another party to this, and that's Plum Creek. And whether we like it or not, we have this bilateral relationship with Plum Creek, to which the counties don't have privity to that basic relationship. And so whatever you come up with, if Plum Creek says they're not interested, we're kind of right back at square one. Now, there may be some public policy, public relations reasons why Plum Creek will participate. They certainly participated in this easement amendment, and they put a lot of things in here that perhaps they didn't need to agree to, such as fire-wise, but it's awfully difficult for us to hold their feet to the fire if, in fact, they can go out tomorrow and subdivide, which they can do. They don't need this amendment right now to subdivide or to sell off property. So
why did they agree to what you have already negotiated?
I've asked that to them myself, and I think that they went into this with open eyes too. They didn't want to buy a lawsuit. There were conflicting views as to what their rights were under those easements. Although they say for all lawful purposes, if they had people in the government saying, no, we think they're limited, they had it in their interest to want to get that clarified. And frankly, I think they wanted this access tied down in an unambiguous way so that when they do market their property, the people and the title companies that are looking at this knew exactly what they were getting into. So I think they had some incentive to want to update those easements. Now, whether or not they wanted to do that in the context of a NEPA thing where any third party could come in and challenge, if I were their corporate lawyer, I'm not sure I would want to subject my client to that type of scrutiny or more appropriately, that kind of exposure. So that's why we try to avoid having to fight this out in court. I mean, my job, as I perceive it, is not to go to court. You put it in the hands of a third party over which you have very little control over what the outcome is. And if we could come out with a situation where the major issues that the Forest Service was concerned about were addressed, I think we were ahead. And the major issues we were concerned about were the proliferation of multiple parties to these cost-share agreements. We were concerned that any development of these roads not be construed to limit our ability to regulate them. And we were concerned about Firewise, and we wanted to avoid any perception on the part of purchasers that this imposed any increased liability or responsibility on the part of the government with respect to those roads on Forest Service land. So in our view, the clarification was worth the effort. At some point, Plum Creek's going to have to decide, though, is this all worth it for them? And all I'm suggesting here is we can agree to all we want, but if Plum Creek's not part of the deal, they have the option of walking.
Well, contrary to the federal government, we all have the limitations of doing our work in public. We don't have the benefit of having 18 months of private negotiations with Plum Creek. Would you expect that at this point, Plum Creek would engage in some kind of public process about the suggestions that counties might have as to how these easements might be amended?
Well, I'm not here to defend Plum Creek. I will say, though, that they have been very forthcoming. They've been very cooperative. They've taken our suggestions. They've come up with, I think, viable and thoughtful counter-suggestions when we had a disagreement. So I think this document represents really good faith efforts on the part of not only the Forest Service, but Plum Creek. Now, if Plum Creek perceives that there's some benefit to its corporate interest to try to placate, for lack of a better verb, issues that counties might raise, I guess you can raise them. I'm just adding the caveat here that don't ask for what we can't deliver, because we're just one party to this deal.
And I think, it probably doesn't behoove us to speculate at length in the abstract, what would be acceptable or not knowing what you seek. If what you seek is for us to go through a full-blown NEPA process every time we do something like this, then you don't have to worry about Plum Creek, because we're not going to agree to that. If, on the other hand, there are some specific things that are missing here that could be materially helpful, then I'm eager to hear them and present them to Plum Creek and suggest that it's in our collective interest to effectuate those changes in the interest of moving this along.
Well, I'll throw one out then, is homeowners associations. I'm sure that every county representative here can tell you how effective homeowners associations are in Montana. They're not. Because people get tired of being the president of the homeowners association forever and get tired of knocking on the door and saying, dang it, you were supposed to pay $100 this year. And so they go defunct. And guess who inherits that? The counties. So guess what that means? These folks back here are paying for it. And so for that to be something that you consider an effective tool in here, I don't think it's going to play out that way. And I also noticed that if the homeowners associations don't carry it out, then the Forest Service is going to go back to maintaining it as what it was designed to be, which is basically a road to access a trailhead or something to hike in the summer rather than to access a subdivision. So I guess, I don't know what else you could do, but that's not going to be an effective tool to make sure those roads are maintained. So if they go defunct and there's nobody taking care of it, what's going to happen to the roads?
Our experience in other states with homeowners associations have been a little bit more satisfactory, and maybe that's unique to Montana as well. But if you have a better idea of a different instrument or organizational scheme that you think works better than a homeowners association, we're willing to hear that. I didn't mean to put you on the spot to sort of say, okay, here's our idea today. I was sort of suggesting that you might take a few days and think about it, and then let us know if you have some things that you'd like to see embodied in this that aren't there, that we might present to Plum Creek in the interest of moving this beyond the current situation.
The one other thing that comes to play in Montana that I don't know if it applies everywhere else is that many of these new homeowners are going to be absent homeowners. These are going to be their second or third home in the country or the world. And so they're not there to drive a plow truck up and down the road or make sure that somebody graded the road, because nobody in Montana can afford to buy a plow truck. So, I think that that's another thing for you to weigh in.
Well, that was the rationale behind forcing them to organize into an association, so that we have a legal entity to pursue to make sure that they pay for their share of the right-of-way maintenance. That being the point of a cooperative cost share agreement.
We had very few. You've hit on some of the toughest things to negotiate, because what kind of clout did we really have to impose some type of enforceable remedy? We had a provision. We have a provision in there right now that if the homeowners association goes defunct, that the period of non-use under the easement kicks in. Now that's 5 years. Presumably, though, that's 5 years that we have to deal with it. We have a provision that says if you're in arrears, we can put a lien on your property as far as debt collection. But collecting money is not necessarily the easiest way to enforce these things. So you raised some very good points, and I guess it doesn't really help the situation to know that that was one of the toughest things we had to grapple with on our side, is figuring out what would really work. What we have in here is probably the best we could figure out what to come up with. But the notion that somehow the easement would terminate if these homeowners associations terminated, that was something Plum Creek was not willing to agree to.
As a concession to local governments and the worry that it'll all come rolling downhill and end up in our laps, would it be considered by you to enter into Schedule A agreements somewhat in perpetuity on these particular easements?
Schedule A, I'm not sure.
The county road use agreements. The counties.
And you don't have to be on the spot.
Yeah, I think we have been pretty responsive to requests from counties for those kinds of agreements in the past. So, if counties believe that that's a better way of avoiding unintended consequences, I think we'd be inclined to look at that.
Mr. Secretary or Mr. Snow, going back to the checkerboard and the public road, say you have a piece of Forest Service land and then it goes into Plum Creek, and Plum Creek doesn't sell that, it's being developed as a subdivision, it comes to the local governing authority. Joe had brought up ingress and egress, but we also require a road for emergency services to be brought up to county standards. So that piece of road is going to be a Forest Service road. Who is going to be responsible to make sure that that is brought up to standards? Are you going to come out and check it? Is it going to lie with the local governing authority to say, no, you need to do some more work on that Forest Service road?
It's your rule, right?
Well, it's for emergency services.
Yeah.
We've been talking about the WUI, we've been talking about fire. You've got to remember,
Yeah.
you might need to get up there, and they're going to have to go over Forest Service Road. Who's going to bring that road up to standards?
I don't want this to sound flippant, but if it's your rule, then it would be your enforcement. If it's our rule, it's our enforcement.
So you would let us do whatever we wanted with your Forest Service Road?
To the extent there's a particular standard to which it has to be brought above what we would normally be using it for?
It would have to be for emergency vehicles. As Gene Curtis said, oftentimes these roads just lead to a trailhead. They get very narrow or winding. They could be, it's all dirt, we require a certain amount of gravel. I mean, you're looking at quite a bit of standards.
I think the way that would unfold is that you would tell the developer that the road standard is inadequate for your rule. The developer would then come to us and renegotiate the cost share agreement for a higher standard. They'd pay for the increased work that would have to be done to improve that standard.
So you would have to approve that then?
We would both have to approve it.
We both have to.
Right. You would have to require it in order to allow the developer to proceed. We would have to approve it with the homeowners association or the developer first, and then the homeowners association second, as a change in the cost share agreement. Not the easement itself, but the subsequent cost share agreement.
Count on that, because it is already required by counties, and it's for emergency services to be able to access that subdivision. So that's going to happen with your roads.
Those that aren't at that standard already. And that would vary depending on the specific road in question.
So if that required widening of the road, cut and fill next to a creek, does NEPA kick in?
It might. It depends on what the change in standard would be at that point.
Some trees may have to be cut too.
Yeah, that would be a subsequent decision that might require additional NEPA work. But that wouldn't put us in a position of simply refusing to grant that. We'd have to go through an additional process to grant this.
Mr. Ray, I'm still a little bit confused. When is it your intention that this easement amendment be signed by the United States government and by Plum Creek?
I'd like first to hear how you would like it modified. Then I'm going to report back to your congressional delegation. And then we'll see what happens next.
Will you provide us with all of the easements and all of the cost share agreements related to those easements so that we can actually review the scope of the document before we comment on how it should be changed? Because without looking at the underlying easements that are to be amended, it seems that it's impossible to actually evaluate the effect of the document.
I disagree. I mean, you can look at a representative sample of the easements and come to some conclusions about what you'd like changed in this template.
You know, it's our experience from looking at a few of the easements that there are reference to other documents in the easements. So without being able to look at each of the easements and receive the easements as well as the documents referred to in the easements.
What you're now asking is that I give you privity in a legal document that you're not really a party to. I'm going to guess that Plum Creek at that point will withdraw from this and proceed on its own to do that. So I urge that you be more realistic in your request.
Mr. Ray, you just invited us to give comment on the document what changes we would suggest, but it's a document that would amend other documents. All I'm asking is, are you willing to provide us with copies of those documents before you expect us to comment on the amendment?
We've agreed that we would provide you some samples of the documents. You're now asking for something substantially more exhaustive, which is all of the documents. I'm not sure that that's really necessary for you to give us some reasonable comments on this template.
Mr. Ray, I thought, then I'm really confused about what I thought you told me when I asked you the question. I asked you the question of, would you provide Missoula County all,
Correct.
A-L-L,
Yes.
of the easements in Missoula County that you are proposing would be amended by this agreement, and you said yes.
And I still say yes. Now you're asking a second question. And that second question is, will I forbear from proceeding at all until we execute that responsibility? And what I've told you is that I don't think it's necessary for you to have all, A-L-L, of the individual easements to give me a reasoned response if you have changes that you'd like on this template.
So it's your intent, am I correct then, to sign this document before the exhibits are attached and referred to the counties for review?
I'll wait and see what you have to say before I answer that question.
I think you can go ahead and, I think you know what the answer is. I just want you here to say it. I mean,
If the answer was as you suspect, I wouldn't have to be here today, would I?
well, one might wonder, but if, my
What I
question, here's the
is
reason.
that you know that this administration will end, and you're trying to set up a scenario so that it ends before this task
That's
is
exactly
completed.
what I was just going to say. I mean, this administration will end in 6 months. Your legal counsel has indicated that it could take up to 12 to do the research on the easements and provide them to us. The implication is this document will be signed prior to the easements being presented, as well as the supporting documents that some of those easements contain. So I'm just trying to get that straight.
If I decide to proceed by calendar necessity, we will proceed before we have given you all of the easements involved. That having been said, I'm still interested, after reviewing a sample of the easements, if you have thoughts about how you would like to see this template amended. And that's really all I can offer you.
Until the template is signed, how do we do business with Plum Creek? Do they have easement or they don't have easement?
They have easements.
So
If they're recorded.
Well,
So if they're recorded, they're not a private document, they're recorded.
well, they can have them and then they can bring them in and record them. They have them in their possession. So they have easements, so we don't even really need to worry about the template or make our comments because they already have easement. So, I mean, we really,
well, that,
and you told me that before. I just
Yeah,
wanted you to reiterate that.
that is sort of what I've been saying, is the heart of the problem here is that they have rights that have already been effectuated, that went through a public process that exist. And I don't have the authority to unilaterally extinguish those rights. What I'm trying to do is accommodate your interests, even though frankly I don't have any responsibility to do that because you're not parties to these agreements, but would be willing to do that if I reasonably can without sending Plum Creek away from the table.
Well, we've been working with Plum Creek for the last 2 years too, and it's real funny, they never brought this up.
Yeah.
We thought we had a good relationship also. If you look at the map behind you, they own 58% of the private land in Missoula County. So that kind of means that we can't really zone without them. And that's what we've been working on. We've been working to try to figure out what are the best places for you guys to develop your land. We're not trying to say they can't develop. We're saying there's some areas that are better for it than others. We agree with you. Subdivision should be closer to existing infrastructure. But then when we find out that behind our backs, they've been and behind closed doors, they've been negotiating with you to make sure that they had residential access to every one of those squares behind you. It kind of throws out our confidence in our negotiations.
Well, I encourage you to continue to work to secure the zoning that you want. I mean, if you want me to come and testify before your state legislature, I probably can see if the secretary will authorize that. But
we have a biannual legislature, so I think you'll be out on that.
Another possibility.
Mr. Secretary, we have a limited number of representatives here from the counties that would be affected by that. Would you be willing to hold other public meetings around the state so that these other counties can have the opportunity to hear what you told us and to comment on that? There may be questions out there that we, as this limited group, have not been able to develop yet.
There's a trend developing here, and that is you're asking me to agree to additional process which we don't believe we have an obligation to do. And what I'm saying is, tell me what your substantive concerns are that I can hopefully try to accommodate. And I think that's the next step of this. Now, if part of those substantive concerns is that we need to have additional public process, I'm willing to entertain that. But that's not sort of where we're at today. You're constructing more elaborate ways to postpone this decision until it cannot be made. And that may be where we end up. I'm not sure. There are several scenarios that could produce that kind of an outcome. But I think we're at the point now where what I'm interested in seeking from you is some substantive concerns that I can evaluate whether I accommodate. Not here today. I'm not trying to put you on the spot in that regard. But I'm also not prepared to agree to a lot more process unless I see some substantive benefits that are going to accrue from it.
Mr. Secretary, you've discussed the benefits of this agreement to the Forest Service, to the United States, but at the same time you seem to be expressing doubts as to whether a subsequent administration would enter into the same agreement. I guess my question is, why do you have that concern, and why does it bother you if people after you wouldn't enter into this agreement?
The people that follow me have the opportunity to do whatever they want, and they will. That's the beauty of the system and why we have elections. All I can do is to try to finish responsibilities I've got the best fashion possible in a way that I think benefits the United States and the public interest. Choices before me are twofold. One, to put this process in motion and underway. Two, to say, oh, it's a very controversial thing, maybe I'll just sit on it and let Plum Creek just pursue whatever development options they want to pursue without the protections embodied in this template agreement. Those are really within my authority to execute the options that are available. Now, within those two options, I'm willing to entertain suggestions from you, which I'm not under any obligation to do really, about how to improve this. And if we can reach an accord on that, then it will be an even better document. If we can't, and I'm beginning to suspect we probably can't, then I'll have to decide whether I'm going to sign it, notwithstanding your unhappiness, because I still think it's a better outcome for the federal government and for the public interest than not.
I guess just looking at that map up there, I see a number of different scenarios with checkerboard patterns, large blocks adjacent to other private lands, other blocks adjacent to other agencies and other ownerships adjacent to the tribe. And without seeing those specific easements, I don't see how we as counties can address all the individual situations that might arise that we might become a party to.
I
if
would
this goes
agree
forward.
if you thought that by reviewing those easements, you were going to materially change their terms. And you're not. I mean, that's the honest truth. The easements exist. They've gone through a public process. They've already conveyed rights to Plum Creek that the company is not going to willingly forbear. On the other hand, if there are things we can do together, short of attempting to convince me to deprive them of their rights, you don't need to see each and every easement to effectuate that outcome.
Just as a point of clarity, where we're going to get those easements is the same place you can get those easements. They're in your county records. So if you wanted to do an exhaustive study and go into your county land records, you can find them just as easily as we can provide them to you.
But you've told us you're going to provide us all those documents. That Exhibit
Well,
A that is referred to there.
What I understood we were going
haven't
to
seen
provide is that when we got a final list, after all the title work is done, we're going to have a list of by book and page number in the local land records as to the easements that we plan to make part of this schedule, or this Exhibit A on this easement amendment. That's the list that we were anticipating providing to you. We're not going to provide a copy of every easement. That'd be thousands of pages. But you would have access to the recordation information where you can go and look it up yourself.
Actually, it's your system of records, not ours.
The Forest Service doesn't have a file somewhere that has Plum Creek and it's got its easements there?
We've got a lot of files with Plum Creek, and they're in a lot of different offices. But the only place that we can really, peg as to which ones are going to have to go with this, is we have to go to the local county land record.
But I think what Jim is saying is we're compiling these nationwide. If you're interested in what's in your county recordation office is going to be a quicker way for you to get that information than waiting for us. We're still happy to provide you the list of easements that will ultimately be part of Appendix A. But you don't need to rely on us for that information.
Mr. Secretary, would there be any attempt to cross-reference any easements that were not filed in the county but are at the federal level? And could those at least be assured that we would be able to see the difference between the two lists?
I'm not sure there are going to be that many that aren't filed. I mean, it's to no advantage of a landowner to have an unrecorded document.
I agree, it just came up earlier, and so that's
If there are such things, and someone can provide an example of them, then first thing we do is insist that that document be recorded, and then the second thing is we would then either add it to the list or not, depending upon what it said. I doubt, since we're the grantors in this situation, those unrecorded documents aren't going to be in our file, although we might have a record of having made such a conveyance. In all likelihood, they're in the files of whoever the grantee was. But I would be, maybe I'm wrong about the way they do things in Montana out here, but I would be very surprised if there are a lot of unrecorded easements out there, at least as between the U.S. government and a major corporation. That might happen amongst various landowners, but in this situation, I wouldn't think it'd be the case. Now, that may prove to be wrong. I don't know.
Are these amendments strictly for the Plum Creek easements?
Yes.
No other private landowners or non-federal landowners, I should say?
Correct.
Yeah.
But you're saying they would apply to any other landowner, corporate, industrial
Successors
landowner that came in and said
successors of Plum Creek, yes.
So you're talking about, you're doing this with Plum Creek nationwide for all 8 million acres there?
No,
If they are adjacent to
just the
Forest
properties that they propose to be subject to this, which would be the ones they want to subdivide and develop.
The ones adjacent to us. They've got lots of land that is not in our neighborhood.
Mr. Secretary, before we adjourn, we would like to ask you to let the public make some comment in the course of this meeting.
Okay, well, we said at the outset that if there's time, we would devote some time to that. And I think we still have some time left.
Mr. Secretary,
Referring back to the easement amendment, on page 5, D, it's talking about National Forest System standards for road reconstruction. Are those set in specific areas? It's, I asked you before about the roads. Do you take, for instance, in southwest Montana, designate certain roads are only going to be this standard?
We have standards for different categories of roads that are in the Forest Service handbook, so.
And so they are set, they're defined?
Correct.
They are defined?
Yeah.
Okay.
And so we usually try to match the standard to the desired use for our land, and then if we are engaged in a reciprocal right-of-way, the use of the other landowner.
So that standard could be changed. I guess that's something that needs to be brought up in this agreement with Plum Creek. That could be changed if there is a subdivision and the road needs to be brought up to standards for emergency services. Are you willing to?
Sure, and depending on what the difference is between the existing standard and what you require for emergency services, it may require a separate decision with its own public process.
Definitely, I think there needs to be some modification there, especially with what you're looking at, what could happen. There should be.
Mr. Ray, let me ask a process question. Are there additional questions from the state or counties for Mr. Ray? We're already about 10 minutes past our original allotted time. And Mr. Ray has some commitments to speak with members of the press and an airplane to catch. So if we are, in fact, to provide some limited opportunity for public comment, we either need to get to that or we need to conclude with hearing the concerns of folks at the table.
I would prefer to make sure we've exhausted everybody's questions at the table. But if we have, if members of the public want to address us for, say, 2 or 3 minutes each, I'd say just raise your hands. We'll call on you in turn. And if you would identify who you are and then tell us what you've got, we'll start from there. And you are the first one up standing.
Thank you, sir. My name is Jason Weiner. I'm an alderman in the city of Missoula. My question has to do with the public process underlying the original easements and whether that public process in fact considered the environmental impacts that residential development would create by virtue of the easements, and if not, then how those original documents could in fact be the basis for saying that this is really a clarification of what was granted at that time.
Since 1969, the granting of a new easement has been accompanied by an environmental analysis under the National Environmental Policy Act and a public comment period. The scope of the environmental analysis focused on the impact of a grant of easement across Forest Service lands on Forest Service lands. And in the course of doing so, the analysis matched the scope of the grant of easements.
So it contemplated residential levels of traffic?
It may or may not have, depending on the terms of the easement. Fellow with white hair.
Yes, well, thank you, Mr. Ray. If I may, sort of summarize what I've heard you say, is that you feel that you would be donning an emperor's cloak. My name is Sterling Miller. I'm a resident of Missoula County. If you made any decision other than the one you're currently making, I suggest that perhaps you're donning an environmental or the emperor's cloak by making the decision that you're making. There's clearly a public interest here in how these Plum Creek lands are managed and developed, and we'd be much more confident that you were reflecting that public interest if you were seeking to challenge the assertions of Plum Creek that they had this right over the interests of the public on this matter, rather than what appears to be an effort to defend and to give a priority to the interests of Plum Creek. I would point out and note that in a year or so, this issue will still be pending. You will probably no longer be Undersecretary of Agriculture, and yet future generations of Montanans and everybody that's around this table will have to be dealing with the impact of the decisions that you make and are making back when you return to being a lobbyist for the timber industry.
It's not clear what I'll return to at this point. This is a case where, as I said at the outset, we're required to balance 4 separate interests. If these easements had been originally granted without any public involvement, it seemed to me the case that the public interest is served by now granting some sort of public review would be a better case to be made. That's not the situation here. Each of these easements, or at least those that were developed after 1969, went through a public process. Now, some of you don't like the outcome of that process, and what you're really asking me to do is to change that process, whether or not I have the authority to do so. And that's fine, you're entitled to make that request. The problem is, I'm not really empowered to grant it. Next.
Yeah, my name is Matt Clifford. I'm the Conservation Director and Staff Attorney for the Park Park Coalition. We're a 501c3 here in town. And I guess I'm kind of along the same lines. I was interested to hear you say, and I guess I've been surprised, that you come in and say basically that your position is that these agreements are completely unambiguous. Sadly, you say you've already given away the farm and there's pretty much nothing you can do. Plum Creek already has this access. And then you read what sounded like a pretty broad granted access in the sample of the lease agreement, saying basically that we give Plum Creek access for whatever purposes it wants to manage its resources. It does say that, but then if you read on and look at the next sentence right there, it also says, subject, however, to our ability to impose the same traffic control restrictions that we impose on any other users of the forest. And as those of us who recreate a lot around here know, some of the most common traffic restrictions that the Forest Service puts on land around here is these seasonal closures to protect things like big game security in the fall hunting season, grizzly bears, other endangered species. And that's the kind of access restrictions that seem completely incompatible with the sort of residential subdivision we're talking about. Because you can't have a subdivision up there in the woods and say, oh, by the way, you're not going to be able to get to it 6 months out of the year. And so I understand, you can look at that and maybe you disagree with my analysis, maybe there's some counter arguments that can be made, but to come in here and say that it's unambiguous completely, there's no arguments you can make, and your hands are tied, I guess I'm a little surprised to hear that. And I guess a bit sad because you seem to regard this as a major disaster to be averted in Plum Creek or some other landowner might sue you, in order to vindicate, their alleged rights. But you don't seem to be as equally worried about the prospect of even our local counties and so groups like mine having to come in and maybe have a case to sue you to get you to follow public participation laws that are supposed to protect our fish and wildlife. And I guess it's a comment. It seems to me that the choice you've made here, that they are ambiguous. You seem to have made a choice to pick one side over the other. I feel like we've got to get back to the table and get in front of it. And just as a final piece of evidence to, I think, consistent with that conclusion, is my understanding, if you look at one of the purposes behind this new agreement, specifically it says in there to avoid protracted and maybe inconclusive litigation. I guess if it's so unambiguous as you say, why would it be protracted litigation? Why would it not be conclusive? It just seems like everyone recognizes here that there are ambiguities. And we just really wish you take a look at the balance a little more closely, maybe balances on behalf of the public and the resources that the agency is charged with protecting. Thank you for the opportunity to come.
Thank you. And I think we acknowledged earlier that we get sued a lot. Don't expect this will be any different. Often our analysis is a comparative analysis and where the litigation risk is greater, where it's less pronounced. In this case, if we proceed on the course that we're on, we'll be sued probably here in Montana, but the other 49 states seem to be fairly satisfied with how we're proceeding.
Secretary, thank you for coming to Missoula today and hearing us out. You seem to be unconvinced that there's a need for any more NEPA analysis. I want to try to persuade you otherwise, just briefly if I could. correct me if I'm wrong, but your position is that the Forest Service has basically already done NEPA when it granted the original easements.
Correct?
Well, we both know that NEPA has a requirement to do a supplemental environmental impact statement and analysis whenever there's either new information or changed circumstances. And it seems to me that you've heard from the county commissioners today a whole bunch of new information about their concerns about the extent of Plum Creek's proposed development plans, which are now rapidly becoming a matter of public record here in Missoula County and other parts of western Montana. So it seems to me, at a minimum, the Forest Service is obliged, as the trustee for these public lands that abut the private lands, to do the supplemental NEPA analysis, to look at the cumulative impacts, and to get that out on the table, because that will let you make a better decision about how to proceed or not to proceed with this easement amendment.
I would agree with that, except for the fact that we have already made the grant of access, and we are not at liberty to change that grant of access. The new information, the changed circumstances, are more germane to executing the responsibilities associated with the regulation of private land, which is the province of the state and the county governments. Now, I will acknowledge that you have articulately laid out the argumentation that I would expect to see in the opening briefs of somebody who doesn't like this outcome. And it may well be that those briefs will be successful, because that will be decided by a judge, not by me. But consider the cost of success. You are going to convert the Forest Service into a regulatory agency that regulates private lands within your counties and states. And it just seems to me that before you take that extraordinary step, that in most states, unpopular step, that you ought to think harder about executing those responsibilities yourselves as local and state government representatives and citizens. You're next.
Mr. Secretary, I thank you very much. My name is Tim Ravendall. I'm with Montana Multiple Use Association, and I also want to thank the distinguished guests here from our delegation for being here, because this is very important. The foundation of our country is the ownership of private property, and I want to commend you on your last statement on standing up and saying it's not right for federal government to come into a regulatory position on private property. Your job is very well noble in controlling these public lands and the resources on these public lands, and the key word is public land. So please take in fact that our efforts here in Montana to protect the rights of private property owners is paramount to everything, and I commend you and everybody else here. And by the way, I am equally concerned because I am a candidate for county commissioner. So, thank you.
Gary Carnivix with the Pacific Rivers Council. Good Missoulian article yesterday described that this whole process started with a landowner here, Condon, who was concerned about the restrictions on his use of his land, and mentioned that there was in process at that point negotiations between the Fish and Wildlife Service and I think Plum Creek, or it may have been the Forest Service, to close some roads because they were a threat to endangered or threatened species. From what I've heard today, it sounds like that sort of closure for resource protection, especially for threatened and endangered species, would be precluded by this amendment. You're shaking your head, so could you explain?
No, as we talked earlier, we still retain the rights in the easements to effectuate temporary closures if that's needed. That's not subsumed by this template agreement. It will be
not a temporary closure, as I understood it from the article, but decommissioning.
A decommissioning. Right, okay. Again, our responsibilities so far as decommissioning is concerned aren't affected by this template. If we decommission a road, as we discussed earlier, without the landowner's agreement, whoever that landowner is, whether it's Plum Creek or a successor in interest, then we either have conducted a regulatory taking, and he is entitled to compensation for that, or we have to sit down with the landowner and negotiate an alternative easement to give them reasonable access through a different direction. So we can still do that, and if necessary, would do that. But our responsibilities don't change with the change of the private landowner. They're spelled out both in the easements and in the underlying law in ANILCA.
So it's a question of whether we have a willing landowner to negotiate that.
Right, and that, that doesn't necessarily change with the change in landowner. Although we always hope to replace unwilling ones with willing ones, we don't often accomplish that. Anybody else from the audience? If not, I thank you all for your patience. I look forward if you want to send us some thoughts about how this can be improved. And once again, I appreciated my time in Missoula.